Greetings and salutations, my fellow sovereigns, and it is raining. We are getting the rest of the residual from the hurricanes that are now coming up north a bit, and so you guys will probably be able to hear the rain in the background a little bit. Hopefully it's not so bad that you can't listen to what I'm saying, hopefully. So with that, tonight we'll be going over and reading from a treatise that we've been reading from regarding due process, and we left off on page 118. The link is in the mega folder, and you can download it at any time. I updated all of the little thought bubbles in there for tonight. And the name of the treatise is A Practical Treatise upon the Law of Judicial Writs and Process in Civil and Criminal Cases. The sufficiency, validity, amendment, and alteration of process, its execution and return, and the powers of liabilities of officers thereunder. And this is a 1895 treatise, and this treatise has been right around the time when they were really trying to get rid of aspects of the common law, and they were really trying to force statute and code pleading onto we the people, and trying to alter common law process to get rid of courts of record, which is of course places where they don't have any power and where we the people actually have the capacity to run courts in a way that are above the magistrate. Okay, so let's get back to, so it's page 118, and we left off last time talking about the seal, and we just had a little bit left to cover at the seal, but this is regarding cases declaring process without the seal only voidable instead of void. There were various different cases going both directions, and we left off that it would be observed that the courts of 7 states have pronounced both for and against the proposition of unsealed process is void, meaning if you don't put your seal on it, it's not valid. And there's a big difference between void and voidable, which we covered before, but just to recap real quick, voidable means that there's something wrong with the process, but it can be amendable, meaning you can go back to the court by leave of the court and say, hey, look, this thing got messed up, or the clerk didn't put something onto it that they should have, and it needs to be amended so we can fix this and then move forward so that no one is losing any substantive rights. However, that's voidable, which you can then amend and fix. But void is something where there's something so critically wrong with it, it cannot be amended. And it's just simply void on its face. Like, say, for example, some cop says, oh, I've got a warrant for your arrest. Okay. And then they show you the warrant, and it's neither signed nor sealed, nor does it have an affidavit to go along with it stating the cause. That would be a completely void warrant. I don't care what the cop would say to you. And if he tried to arrest you, that would be a felony, because it would be aggravated kidnapping, because cops carry deadly weapons on their side, and so therefore it would be aggravated kidnapping. We'll just finish up this a little bit with the seal, and then we'll get on to the next section. Okay, thus we have the weight of authorities in favor of the proposition that a writ without the seal is voidable only and amendable. The courts of 12 states and territories so declaring, while those of 9 states pronounced unsealed writs void. And we'll skip down to the next section. And once the seal was everything and the signature was nothing. Now, the reverse is true. The signature is everything and the seal is nothing. Now, I don't necessarily agree with what this guy said. I fully disagree with this statement. The use of the seal brings with it the higher law of your house as a sovereign. It also, in matters of contract, elevates the matters to a covenant. This cannot be understated, and also is a matter of law. And he doesn't mention anything about a covenant. Who knows if he even knows about it one way or the other, but I don't agree with what he says here. So, and it says, thanks to advancing intelligence of the age. Well, at the same time, you're taking away the power of what the seal was meant to convey, which was the validity of the court, the understanding of who and where the authority was coming from, and that you knew that the authority, that it was coming directly from the authority, because only the authority can hold the seal. And that's kind of the whole point of it. So to continue here, statutes as well as courts are fast favoring the doctrine of amendment, which tends to promote the ends of justice and has been truly called the wisest and most beneficial part of our law. Now, that's talking about all aspects of amendment. So if there's some error that you've done or some error that the court's done, you should always bring it up. Do not let them just continue on with something that's clearly voidable. Make sure that they fix it. And if they don't fix it, or if they don't get around to it, or say the attorney gets lazy or the district attorney gets lazy and they don't get around to fixing it and their time runs out, okay, then you can dismiss for lack of speedy trial because you found something that was wrong. You demanded they fixed it. The court said, yeah, they should fix that. They don't fix it. Their clock runs out, and then you get the whole case dismissed. It's kind of an aspect of tactics, if you will. To continue, the author declares without hesitancy or equivocation against the doctrine that the omission of the seal renders process void, where I, on the other hand, do not. We freely assert that such defect in a writ should be regarded as voidable only and always to be remedied by amendment. This will not lead to the disbursement of writs so as to destroy their identity. The decision of the Supreme Court of Minnesota that a writ of attachment without either the seal of court or signature of the clerk was void is not to be questioned. Now, that's obvious. So the standpoint that you can remedy things within reason also makes sense. I believe there's a maxim that states that form should not deny substantive right, if I recall correctly. And that makes sense, because if you mess up a little thing here or there, it shouldn't deny you your substantive right to reclaim your property and so on and so forth. But it should be made known that whatever it is needs to get fixed. Okay, so next chapter is 9, the signing of the process. A signature independent of seal. Once the seal was everything and the signature nothing. In modern times, the signature is regarded at least as much importance as the seal. It has been a matter of controversy whether the seal authenticates the signature or the signature proves genuineness of the seal. Neither assertion is correct. Each speaks for itself. If one were essential to prove the other, its absence would be of greater seriousness. The signature is independent evidence of the authorized delegation of the power of state in judicial proceedings. It is only a part of such evidence, however. It, quote-unquote, serves to identify process. The defects in process extend to the signature, the effect of omitting the signature of the proper officer, or of an insufficient signing of process is now to be considered. Section 38. Cases declaring unsigned process void. As the omission of the seal has differently impressed the judicial mind, as disclosed in the preceding chapter, so has the omission of the signature produced conflict in its authorities. A surprising feature of this controversy is that some of the courts, which declare with emphasis against the validity of a writ without a seal, have pronounced unsigned process voidable only. Well, I think it would entirely depend on what on earth was required to be signed. If it was an arrest warrant and it's not signed by any judge, that's just void on its face. But I kind of see the point of the writing here. You know, it says a surprising feature of this controversy. Well, not surprising. So anyone and any attorney or any court or any judge that's trying to get rid of the requirements of seals and signatures is going to try to push both issues as far as they possibly can, which is kind of what they're saying here. So thus is evidenced too frequent judicial disregard for the principles that underlie the question at issue, and which alone can correctly solve the controversy. In one citation in a proceeding by writ of error, United States Supreme Court was not signed by the clerk. For this omission, the writ was dismissed. Where a writ issued bearing the signature of the clerk, but which was written by an attorney, the court declared the writ was not properly signed and that the sheriff was justified in refusing to execute it. And that's what you're always worried about, is attorneys just doing things on their own volition and then trying to make it as though they have some sort of authority to do that. Next section, the reasons which are given to support the proposition that unsigned process is void are stated in the quotations which follow. Quote, the signature is as essential as is the seal, and in its absence, the writ must be held to confer no power on the officer to whom it was directed. Quote, the writ without signature is no more than a blank piece of paper and must be held void and not amendable. So when they're trying to say up above, oh, well, if it doesn't have the seal, it should be amendable, or that it doesn't have the signature, it should be amendable. Nah, it should be held void. And that's something that I completely agree with. Okay, I'm going to skip down to section 40. Author's views, same subject. Though it is said that the signature authenticates the seal and that the former is everything and the latter nothing, yet it is seen that reason and the weight of the authorities are in favor of the proposition that process, again, just to kind of do a little review, process is anything that comes from the court, whether it be a writ, whether it be a order, whether it be a summons, whether it be a subpoena, all of that is considered process. Okay, so in favor of the position the process, otherwise in form, is not valid because not signed by the clerk. This is but the enforcement of the doctrine that the law favors substance rather than form, which is kind of what I said before, and will not deny substantial right to the citizen because of the misprision of an officer of state. The author is entirely satisfied to assert that an unsigned writ is voidable only. Well, again, I would say it would depend on what it is. If it was writ of subpoena, nah. All right, skipping down to section 42, defects in signature. Now, this little part is, I found, fairly fascinating. A statute required the endorsement of, quote, Christian and surname, close quote, of plaintiff's attorney on process. It was said the surname in full and the initial only of Christian name was sufficient. Initial of Christian name of clerk to process is good. So of justice of the peace also. Process signed by clerk with his initials only is said to be valid. Now, the interesting part of this. So to be clear here, your Christian name is the aspect of your first and middle name, i.e. John Henry. And your surname is, quote unquote, your last name, i.e. Doe. So by this, we can see that one would not have a first, middle, and last name, but a Christian name and surname. So when you're talking about properly putting your name down on a document, or if someone says, what's your first, middle, and last name? You say, I don't have a first, middle, and last name. I have a Christian name and a surname, if that's what you want. And that makes it clear as to, and again, this is an aspect of common law, and again, we are reading straight out of a treatise. So just realize that that's important, that it's your Christian name and surname that you're putting down on your documents when you are acting in your sovereign capacity. Okay. And we're going to skip down again and come to chapter 10. A writ of summons. Now, this used to be a writ, and they now just call it a summons because now you're having things done in statute and they don't call it a writ of summons anymore. But in a court of record, you could still create a writ of summons. So, section 43, nature of the summons. Having treated of the ceremonial dress of process, we now come to the consideration of the body of writs. The discussion of this subject will extend to several chapters entitled by the names of the different writs, now in actual and common use, and first of the writs of summons, which is the authorized and formal notice to the defendant that he has been sued, and which is essential to the due administration of justice, and peremptorily required by the constitutional declaration that, quote, no one shall be deprived of life, liberty, or property without due process of law. And in case anybody doesn't know what peremptorily is, because I certainly didn't today, putting an end to or precluding a right of action, debate, or delay. Specifically, not providing an opportunity to show cause why one should not comply with a peremptory mandamus. Admitting of no contradiction, expressive of urgency and command, a peremptory call. So that's what it means in regards to the constitutional declaration so said. To continue, as will be more fully shown in the chapter concerning the amendment of process, this wise principle of law extends to the body of writs. Defects, however, may occur, which will render process void and therefore beyond the remedy of amendment. The information which is required to be contained in every summons concerns the nature of the action and the time and place for appearance and answering. It is also important that the writ command its return by the officer. Meaning that, yep, I served him, he knows he's been sued, and he knows the location and what he's being sued for. Section 44. Statement of nature of action, amount claimed, and miscellaneous matters. And first, the nature of the action. In many of the states, there are code provisions concerning the information to be contained in the summons as to the nature of the action. This also goes to make a point here, this also goes to the constitutional aspect that one is required to know the nature and cause of the actions or charges against him, or the criminal actions against him. So nature and cause, if they don't give you the nature and cause of what it is, then you can attack it based upon its lack of constitutionality. Okay? Aside from statutory provisions, every writ of summons should contain a sufficient statement of the cause of action as to indicate its nature and apprise the defendant with sufficient certainty of the legal character of the suit, which is exactly what I just said, the nature and the cause. This omission may be supplied by a copy of the declaration. And just to make a point here, okay, this omission may be supplied by a copy of the declaration. So in the writ, you're saying, hey, this is what you're getting sued for. Here's the nature and cause of why I'm coming after you. Now, the declaration itself is a part of the suit. So there's 9 parts to a bill in equity and 7 parts to a declaration at law. And the declaration is part of the suit itself. You can think of a suit at law as pretty much just the totality of it being the declaration. And I've covered declarations before, and specifically in the ins and outs of court class. So if you want to learn more about declarations, check that class out. Or you can just always pick up a treatise on declarations in general. Okay, the omission may be supplied by a copy of the declaration or petition accompanying the writ and being served on the defendant, or by special reference to the declaration or petition, such being duly filed at the court. Now, what does duly mean? Duly refers to matters that are correct according to common law and statute. So when it's in accordance with both common law and statute, that's when you use the word duly. So it was duly noted. Sometimes you'll hear a judge say that. So when you object to something and they say in court duly noted, that means that they're taking note of it on both the common law side and the equity side. To continue, a statutory requirement that summons must contain, quote, a statement of the nature of the action in general terms, close quote, does not necessitate the statement that the amount sued for is due for work and labor or for goods sold and delivered, or the kind of lien or to what property it attaches. Skipping down, quote, of a plea in the same summons to be mentioned as used in the statute held to require summons to contain a statement of the cause of action. Again, nature and cause. And a summons to answer of the complaint of C to his damage $100 or under, close quote, is not sufficient to confer jurisdiction. So this just said, I'm suing you for $100. Okay. Why? You have no knowledge of why you're being sued. And that's not sufficient to confer jurisdiction. And you'll often see, and just to make a point about this, like in civil actions, every single attorney, the first thing that they're probably taught in law school is that whenever somebody files something against your client, the first thing that you do is file for a motion to dismiss for failure to state a cause upon which relief can be granted. And anyone that's ever sued anybody, particularly a public official, you've always seen that as the first thing that the attorney will file. Does it matter necessarily? No, because they're just told to do it anyway. Even if you have properly stated the cause upon which relief can be granted, they'll file a motion against it anyway. So just be aware of that and just be prepared that you're going to get that motion to dismiss from every single attorney. So be sure when you write your suit, your declaration, whatever it is you may be doing, just make it very clear what the cause is and the statements to stand on in order that relief may be granted. Chat says, is equity governed by statute? Well, statute is equity. Statute is equity jurisdiction because it's a matter of contract. It's a matter of consent. Equity is in general, anything that has to do with an agreement, a trust, a contract, and statutes are pretty much all equity because we've all agreed to them in some way, shape, or form. So to ask the question, is equity governed by statute? I don't want to say is a nonsensical question, but it doesn't exactly mean what I think what you're trying to think it means. Equity courts deal with matters, like I said, of what I just said. Now, equity courts, you could say, okay, I'm in a statutory court. Am I in an equity court? Yes, you are, if it's dealing with statutes. So, but are all matters of equity governed by statute? The answer is no, because you could have a trust that's created, not governed by statute, but still gets adjudicated in equity. You could have a contract, obviously not governed by statute, but governed by the terms and conditions within the contract or covenant, and that would be adjudicated in equity and not governed by statute. So I hope that answers your question. Okay, I think I'm going to skip down after this one to section 45. Statement of time and place for appearance. A summons which fails to mention the time and place when and where the defendant is to appear and answer is no notice at all and will not support a judgment. This is an elementary proposition and requires no citation of authorities to support it. And place includes the name of the court as well as its location. Skipping down again, I'm going to be doing this quite a bit tonight because obviously this treatise is 700 pages and I'm not trying to read the whole thing. So, section 46, name of the parties. A writ commanding officer to summons trustee Cicero School Township was declared to be against the township and not against trustee individually. A citation to summons W.J. Sayer, agent for the Gulf, Colorado, and Santa Fe Railroad Company, to be and appear, close quote, etc., will not support a judgment by default against the railway company because this guy was clearly named. So if this guy is the one that's named and he's the one that's getting sued, well, then it's not going to fall on the railway company. And you could do that vice versa as well, as the first one said. So it was declared to be against the township and not against trustee individually because it just names the township. It doesn't name any specific trustee, right? Where here it's specifically naming one guy, an agent, and not the railway company as a whole. So again, make sure that you're paying attention to that when you're deciding to start suing judges or cops. A summons to A, administrator of B's estate, is against A, personally, and not against the estate. The words, quote, administrator of B's estate, close quote, being considered as descriptio personae and rejected as superfluous. The Christian name being given incorrectly in summons, but properly in declaration, will not avoid judgment by default. So again, declaration, again, is the body of the work, the body of what the thing says. So from that standpoint, if the body says, hey, this is what the guy is, that's all correct, his name's correct, and his address is correct, and everything else is correct, well, then that's correct. And it's always the body that controls, not your titles as well. So your title of something, if you screwed up the title of something, that's completely amendable. But if you screwed it up in the body of the suit itself, within the declaration, that's void. So you cannot screw that up. Okay, and that's the reason why I believe it's from Bill Thornton that I learned that titles and headings do not control. And my little note here, this is making the point that it's the body of the document suit declaration that controls, right, which is what I just said. Okay, skipping down. A summons to Augustus Weil was served on Gustavus Weil, the defendant who failed to appear and held no jurisdiction was acquired over defendant. Again, small change, still matters. Next section here, a person who is served with summons which contains his name as that of defendant, but which he believes to be intended for another person of the same name should appear and defend. And how would one do that? They would do that by plea and abatement. You would say, hey, wait a second. Is this what you're suing? Is this who or what you're suing? That's basically what you're doing in a plea and abatement. You're saying, okay, I don't know what you're suing. I'm doing a plea and abatement to demand that you specifically state who or what it is you are suing. And in all of these private for-profit courts, of which all of their process is all suing in rem, meaning against a thing, they're all suing constructive trusts because that's what the court case is. They're creating a constructive trust and then they're suing it. And you are wandering in there as a trustee and accepting the charges and accepting that you are subject to the statutes, acts, ordinances, or codes. When the judge says, do you understand the charges against you? And you say, yes. Okay, well, you just agreed that the statutes apply to you. Instead of saying, well, wait a second, what you're doing by a plea and abatement is you're forcing the other side to answer who and what it is they're suing and be very specific as to the name also. Particularly if it's in all caps, you can say, look, my Christian and surname are not in all capital letters. So what is the thing that you are suing here? And there have been VSOF members that have forced this, an aspect of plea and abatement, onto the court. And we have gotten the district attorney to completely agree that the defendant was a trust, which was kind of interesting. So anyway, all right, to continue. If he disregards the process, relying on the mistake in identity, and judgment is recovered by default, it will be operative against him. So meaning, get your shit filed and argue it correctly, and do not let them just come with a default judgment against you, even if the name is completely incorrect. Or if you completely understand everything I just said to you. You still have to put it in to the paperwork. Okay, in some cases cited in this section will not stand the test of the doctrine of idem sonans. Now, what is idem sonans? Now, anybody that's got their doc set done, you already know, because I have this term all the way through the doc set in various different places. But this is what it is. Adjective. Relating to or being two names having same or similar pronunciation or sound. The two names are not idem sonans. This is from a specific court case. And the way that I use it in the doc set is to state that I state the name, and then I say that this is the name of the estate and idem sonans of any other form of this name. Meaning, we are claiming the estate in any and all forms of which they wish to write it down. Capital, non-capital, upper and lower case, forwards and backwards, last name first name last. I don't give a damn. We're covering it all by idem sonans. This is what it is. This is what I'm claiming. This is the name of the estate. So that's how I use it. What they're talking about here, some of the cases in this section will not stand the test of the doctrine of idem sonans. Where names sound alike, mere misspelling will be immaterial. But to serve an intended defendant with notice of the commencement of a suit which contains a name that fails of the purpose of names, identification, will not require the appearance of the party served, and judgment against him will be a nullity. In such cases, if the real party appears, although specially, and not for the purpose of abating the writ, it is proper that the writ be amended by correctly giving his name. Okay, so let's just go over that sentence for a second here. In such cases, if the real party, now what they mean by real party means a real party in interest, meaning you actually have interest in this case. So if the real party appears, meaning they make appearance, although specially, meaning they're making appearance specially, not generally, because if you're going to challenge the jurisdiction of the court, you're always there specially, not generally. Anytime that you make a general appearance, you have conceded to the jurisdiction of the court and that you agree that the court has jurisdiction over the subject matter and in personam, and even to a certain extent, even regarding proper venue, right? That you did something in James County and they're holding it in Winnebago County, and you're not savvy enough to bring it up and say, hey, this didn't happen in Winnebago County. What are you guys pulling me into court here for, right? Well, all that's waived under general appearance. Now, there are some things, granted, that are never waived, but I don't want to get into that whole list. The point that I'm trying to make here is that when you're appearing specially, you're there to challenge the jurisdiction of the court. That's what they're talking about in this sentence. Okay, in such case, if the real party appears, although specially, and for the purpose of abating the writ, meaning by plea of abatement, it is proper that the writ be amended by correctly giving his name. So that's what you're doing by plea and abatement, saying, this is my Christian and surname. This is what I am, and I am not this other thing, or whatever it happens to be on this paper. That's not me, right? So where a writ is served on a person of a different name, from that of the one against whom the summons runs, and there is no appearance, the service is not good. What does that mean? Okay, writ is served on a person of a different name, say Jack Doe instead of John Doe, from that of the one against who the summons runs, and there is no appearance, meaning Jack doesn't show up because obviously it's to John, not Jack. The service is not good. Service of a summons on Asher B will not warrant a judgment against Ashley B, nor on Jonathan McCarver against John McGravy. All right. So again, if anybody wants an example of a plea and abatement, there's one in the mega folder for this class. Just look into the show notes, no matter what platform you're on, and it'll be in there. Okay. Section 46A, miscellaneous requests and defects of summons. That the amount claimed is stated to be less in copy of summons than original is immaterial. The declaration will control in the matter, as I've said before. A defect or irregularity apparent on face of summons is not subject to plea and abatement, but can be objected to only by motion to quash. A summons for $30 when complaint is for $300 is invalid. The court said, quote, a defendant summoned to answer to a demand of $30 may decline appearing to the suit for the very reason that he is satisfied he justly owes that amount and is willing the plaintiff should take judgment for the sum demanded, but it would be a gross wrong to him if the plaintiff could summons him into court to answer to a demand for a sum he does not deny that he owes, and then turn around and demand and recover in his absence a much larger sum against him. So when you get those things messed up, again, make sure that all your numbers are correct. If you're having multiple suits against someone for multiple different amounts of money, make damn sure that in the final prayer that you're stating, and of course you don't have to call it a prayer at law, but in the final aspect, the demand in the declaration, let's put it that way. The demand in the declaration, make sure you do all your addition correctly, okay? So just be aware of that. Because you can't default someone on bad math is basically what they're getting at. Skipping down a little bit to continue. Failure to name in writ of summons the court from which it emanates is an irregularity which is waived by what? A general appearance. Again, this is another point that I'm making. This is but one reason why one should never make a general appearance. For making a general appearance will waive many irregularities and will then bind you to the jurisdiction, even if you would not have been bound otherwise, meaning that you actually properly collaterally attacked whatever it was that was fucked up, and you don't have to go now, or you can just defeat the whole cause because, hey, they screwed this up, they screwed this up, they screwed that up, whatever. Get rid of it. Okay. You have to do all that before you walk in there, meaning before arraignment. And I know sometimes you get pulled straight out of jail and go straight into arraignment. Okay. In those situations, do everything that you can to simply come upon verbal motions, which you can do at any point in time that you want to, because your verbal language is stronger than any written word. And that's been the same all the way going back to Rome, like long time ago, into the BCs. Your word is stronger than what is written. So if you say, Your Honor, I come upon a verbal motion to dismiss for lack of subject matter jurisdiction, lack of in personam jurisdiction, and lack of venue, and state that I'm only appearing specially, not generally, to challenge the jurisdiction of this court, they cannot then consider you to have made a general appearance straight out of the jail cell and thrown into their little private for-profit court. So just be aware of that you have the capacity and the right to do that at any time that you want, even if it's just verbal. Okay, to continue. A writ commanding officer, quote, to summons the unknown children, close quote, of certain parties is invalid, where statute authorizes the officer to summon the defendant named in the writ. And just to make a side note about that, where statute authorizes the officer to summon the defendant, such and such. Okay, where statute authorizes. Read your statutes. Read what the state is supposed to be doing. The two things that you very, very much want to read is your state's criminal procedure. So find the statutes on criminal procedure and read them from start to finish. They read just like an instruction book. And if the state doesn't follow them, that's where you can file motions to dismiss. And also, if you're going to get in a position or wish to be in a position to sue someone else or to even file a high prerogative writ, there's going to be rules in the statutes for that as well. Now, there might just be rules of court when it comes to high prerogative writs. You might not find that in the state statutes. They will be in the court rules, which may or may not be listed in certain sections in the general statutes. But you're going to want to look for these different things wherever they may be and track them down and just simply follow them and force them to follow them. Because if they don't follow them, well, then it's considered a trespass upon your substantive rights and you instantaneously get to move for dismissal. Okay. So skipping down, next chapter, the writ of subpoena. And again, this is now just called a subpoena. Usually this subpoena duces tectum, and I might have just butchered that pronunciation. Don't hold that to me exactly to be what it was. But again, at common law, it was a writ of subpoena. And in equity, you're going to have the subpoena duces. I'm just going to say duces tecum. I'll do that just for placeholder. Okay. So importance and purpose of the writ. The writ of subpoena is issued to command the attendance of witnesses and is included in the meaning of the term men's process or middle process. It is indispensable to the proper trial of every cause, but is of plain and brief form. It should inform the person to whom it is directed with reasonable certainty of the title of the cause, the party in whose behalf the testimony is desired, meaning I'm the defendant and I'm subpoenaing so-and-so, my neighbor, because he saw the whole matter, or the state says I'm subpoenaing so-and-so cop because they witnessed the defendant do X or whatever, and the time and place and when he is to attend. So what's the time? What are we doing this? When's the trial? So on and so forth. It should also contain the command to testify. So don't just tell him to show up, but tell him that he's got to also show up and testify. Skipping down a little bit, the purpose of the subpoena duces tecum is to require witnesses to bring with them to the place of trial documentary evidence, which is in their exclusive control and possession. And I made sure to put the definition in here. It is a legal term that means bring with you. So that's what duces tecum means, bring with you. It is often used in a subpoena duces tecum, which is a legal order that requires a person to appear in court and bring specific documents or records with them. And Chet said some of the statutes are actually pretty readable. That's true. Some statutes in some states are very simple. Michigan, very short when it comes to criminal procedure. Colorado, ridiculously long, like 2,000 pages, stupidity long. However, what Colorado is doing is they're giving a lot of court cases. So technically you don't even have to go look up the cases. They actually remake them. I think they reprint the entirety of the procedure, I think every 3 years, every 4 years, maybe in Colorado. So even all the case law is kind of up to date. And so attorneys really don't have to look for anything in Colorado. So, and Leah said, I was looking for some references for process service in the statutes in Maine, compiled statutes, and found what I was looking for pretty easily. They are searchable too. Yes, they are. And if they're not really super easily searchable on the state websites, usually you'll be able to find a PDF, and sometimes you can find a PDF of the whole thing, which is really, really nice because then you can search the whole entire thing for just a single word and you can go directly to what you're looking for. So, okay, to continue. Section 48, the writ of subpoena duces tecum. Much more is required in a subpoena duces tecum than an ordinary subpoena, where under the practice of the court, it is necessary to obtain the order for a subpoena duces tecum. The order obtained is the authority for the subpoena, and its terms must be followed in the subpoena. The application is ex parte, meaning you don't have to have both parties there to go ask for this specific subpoena, and ordinarily granted as of course, meaning that the judge sometimes will sign it, but not always. Sometimes just the clerk will sign them. So you can go and have a subpoena, write it up, take it to the clerk, and they'll just sign it. And then you can go process serve it on whoever. And to make an interesting point about this particular type of subpoena, when you're subpoenaing a document, you can raise a hell of a lot of havoc, particularly in foreclosure cases, when you start demanding the production of particular documents regarding your mortgage. Like, say, when did the note specifically go into the REMIC, and so on and so forth, right? I don't want to get into mortgage cases, but the point is that the banks are not going to have a lot of these things. And because they don't have them, then it means they can't prove that they have the right to foreclose, is kind of what I'm getting at. So use it wisely. And again, don't hesitate to use it, because you can just write one up and then take it to the clerk and they'll sign it and you can just serve it. That's it. So to continue, the order is not criticized by the court at the time. As I said, the party applying for it drafts it in his own form and takes it at his peril. Just sign it, seal it, give it to the clerk, tell him to stamp it. That's it. Subpoenas duce tecum directed to a person, not a party, must describe and specify the papers desired with that degree of certainty which is practicable considering all the circumstances of the case, so that the witness may know what is wanted. In a New Jersey case, a writ of subpoena duce tecum did not contain the customary words commanding the witness to testify. It only commanded him to be and appear and bring with him a book. The omission was declared to be fatal to the validity of the writ. It was said, quote, of the reason why he was to appear, or what he was to do when he got there, nothing was said. The defendant, doubtless, wanted only the complainant's book and not his testimony, and hence the omission. But the omission is fatal to the authority of the writ. The power of a court to compel the attendance of a witness is derived from the purpose for which he is to come, vis-a-vis, to give evidence in some action, suit, or proceeding pending before it. An arbitrary, capricious command to go here or there would obviously be nugatory and vain. This is the difficulty with the present subpoena. Had the complainant appeared with the book, no use could have been made of it without his consent, for a person actually present at the trial may refuse to be sworn as a witness unless he have been duly subpoenaed. Right? So if you're duly subpoenaed by the court, you have to come testify as to what it is. But if he just said, bring the book, but he wasn't duly subpoenaed to testify, well, he doesn't have to say anything. Okay, here's the book. And what? Right? So that's why it's void, not voidable. Departures from established common law forms are apt to be found in departures from the substance to which the forms were originally and nicely adjusted. The complainant cannot be deemed guilty of contempt when it is this sort of thing that's non-specific. Okay, next chapter, the writ of execution. The nature and purpose of the writ. The writ of execution is the final process in an action and is the authority which emanates from the state for the enforcement of the decree or judgment of the court on which it is based. These are also now sometimes called writs of assistance. You'll usually see them called writs of assistance when it comes to mortgage foreclosure. Sometimes they'll be called writs of assistance even in repossession situations like of cars and whatnot. So every court has inherent power to issue writs of execution on its own judgments. The writ must describe a judgment to sustain it and must disclose on its face the authority to issue it. Style and direction, teste, seal, and signature constitute the ceremonial dress of the writ of execution, as of other process. The constituent parts of the body of the writ are the command to the officer, the description of the judgment, which discloses the authority to issue it, and the direction as to the return of the writ, meaning bring such and such car back to such and such place or whatnot, in which the time and place are stated. So all that has to be correct. Mess up any of that, again, fatal error. Section 5, variance of a writ of judgment, cases declared variance immaterial. It is an elementary proposition that writs of execution must follow and conform to judgments which they are to enforce. This is true whether the writ be against the property, fere fascisa, I believe it's stated, or against the body, ad satisfacti addendum, I think. Forgive my Latin. Material variance from the judgment renders the writ void. The principle is of easy announcement but difficult to understand and enforce. No rule has yet been announced which comprehends an established definition of the phrase material variance, and each case has been considered a law unto itself, which is why I double highlighted that. And this aspect, of course, is that which we know of basically the understanding of case law or holdings of a case. So in certain cases, the court held X. In other cases, the court held Y. And there are the reasons, right? So there's no specific nailing of this down, if you will, right? As far as the cases declaring the variance immaterial. So that's just really all I wanted to say about that. So, all right, now skipping down quite a bit here because they get into all these different aspects of what is and what is not. So writs of execution may be amended as to matters of form, but not as to matters of substance. This is but the assertion that defects in the writ which do not destroy its substance render it voidable only, which we've kind of stated previous. Section 52, cases declaring variance material and writ void. A presentation in the cases upon the topic under consideration discloses a surprising conflict in the authorities. No less a jurist than Judge Redfield declared a writ of execution void, which varied from the judgment only in the matter of amount to the extent of 67 cents in excess. Right. As I said, get your math right. And with seeming satisfaction, he said, when the judgment is thus misdescribed, it is the same as if there was no judgment upon which the subsequent proceedings rested. For, in fact, there is no judgment as is recited. So if it's incorrect, it's incorrect. And where the execution called for interest, the judgment allowing none, the variance was said to be fatal and the writ void. A judgment is an attachment proceeding in rem, an execution described, it is in personam, was declared void. Okay, now what are we talking about here? These are the two different types of... All right, there's more than two different types, but just to put these in contradistinction to each other. In rem means against a thing. In personam means against a person. Or the man, really. You could say of the man, because you don't want to get this idea of person that everything stated is in personam would be incorrect. So it's against the person. Means against the man, in personam. So, as I said before, what are they doing in all these private for-profit courts? They're running everything as an in rem action. It's always against a thing, which is where you are stating, hey, no, hold on. You don't have jurisdiction over me, which is a lack of in personam jurisdiction, okay? Just want to make that point. All right, now we're going to skip all the way down to page 174. So this is the writ of replevin. So I did a definition here. These are from Bouvier's. Writ of replevin, practice, the name of a process issued for the recovery of goods and chattels. So a writ of replevin or an action of replevin is definitely an in rem action. The name of an action for the recovery of goods and chattels. It will be proper to consider 1, for what property this action will lie. 2, what interest the plaintiff must have in the same. 3, for what injury. 4, the pleadings, and 5, the judgment. And this goes on and on. I'm not going to read all of this, but you guys can get all of that in the specificity of the definition of replevin. Okay, principal feature of the writ. The most important and interesting feature of the writ of replevin is the command to seize and deliver to the plaintiff the property described therein. The other interesting thing about this writ is that when you do an action of replevin, you go and take the thing back first, and then you go to court and determine whose it is, which is a very kind of sort of backwards way of doing things in a sense. But with a replevin, you have to post a bond into your own case on the validity of what you're stating in the suit and that you have the right and the title to this thing that you're going and getting, and that if it be proved that you do not, then the defendant then gets to cash out the bond as a way of being compensated for being rung over the coals in court when you didn't really have title to the cow, per se. All right, so to continue, the law is not satisfied with an indefinite or uncertain description of the property to be repleved. but prescribes a rule by which the sufficiency of the description is measured and determined. Exactly. So if you say, I am filing an action of replevin to go reprieve a white stallion from John Doe's location at such and such address, and the officers go with you, you have the writ, it's signed by the court, you've placed your bond, you go into John's house, and there is no white stallion to be found, but there's a black one. Can you take the black stallion? The answer is no. So, got to be specific. Can't take a black when it's supposed to be white, and can't take a different model of car per se. Can't even take a different year of car per se. If they've got two Chevys sitting out there and one's a 94 and one's a 95, well, you got to get the year right. Okay. And we're going to skip down to next section. And just kind of, you guys can go through these. So cases of insufficient description of property, that'd be kind of like I said, the black horse to the white horse, or vice versa. The rule as to description of property, that it has to be specific. And this little part here, a description that would support an action in trespass, trover, or detinue would not necessarily be good in replevin, because in the former actions, the value of the property and not the property itself is sought, which is just kind of what I'm getting at. So in trover or detinue, you're just asking for an amount of money because whatever the thing was, like, let's continue the example of the white stallion. So in those other actions, and it's an aspect that John already, or that Jack already sold the white stallion, and you're demanding money because it's already been converted. While in replevin, the property is the subject matter of the litigation, and its identity is frequently in dispute. That's why you have to be so specific about it. But a description that will sustain a chattel mortgage will be sufficient in replevin, and so a description that is sufficient to pass title. So anything that you would have in passing of title, like the description of anything, doesn't matter what it's a title to, we don't care, but anything that would be a description of a title, whether it be a house, whether it be a car, whether it be a horse, whether it be a dog, I don't care, that's sufficient as to whatever that may be. Okay. If the writ is without any description, it is, of course, void. The question of sufficiency of description is for the court to determine. And then we're going to skip down again. All objections to the description must be made at first convenience, or they will be waived. Again, someone shows up, or they bring an action to you and say, yep, I'm coming for your black horse. And I say, I don't have a black horse. I've got a white horse. And then you have to then go and quash that writ and say, nope, you have no business being on my property because I don't even have a black horse, or, vice versa. So giving bond, and to continue here, giving a bond to retain the property or pleading to the merits will waive such defects. So basically, just go fix it. And my side note here, in an action of replevin, you actually post a bond for the amount of the thing that you are going to take back, as I stated. This is done so that if you are found not to have had title to the thing that the defendant can sue out for the bond and be compensated in turn for your mistake or your stupidity. Okay, with that, I think let's stop here at this chapter, and I will make a note here. So we'll come back to page 179. And before we end up for this evening, does anybody have any questions about or comments about what we've covered tonight up to this point? Nope. Okay. Sounds good. And you guys can always ask questions later in Mega if you wish to. And also, anybody's also welcome to join our Revolt server. We are no longer on Gilded, for anybody that doesn't yet know that yet. And to join the Revolt server is quite easy. The links are in all of the show notes in every single class, no matter what platform you're looking at. Just click on the Revolt invite link. You'll then be prompted to create an account. And then after you create an account, just go ahead and back out and then hit the link again. And then it'll bring you to our server. And this will bring you to the landing pad, of which then you'll be prompted to go to the Start Here page and download the welcome package. And how to get started is all within that package. Make sure that you send friend request to me when you get here and send me back the welcome package. And then you will have access to all of the rooms that we have. And one little aspect of housekeeping purposes, Revolt's been being a little bit buggy recently because Russia and Turkey decided to completely remove Discord and not allow Discord to be used at all in their countries. And because of that, you have several millions of people now rushing to try to find other platforms which were similar to Discord. We are no longer on Discord because it is run by the CCP, probably also the same reason why China and Turkey decided to cut them off. But because of that, there have been large influx of users. Service may be degraded at times. So right now, Revolt is literally going and buying more servers. They are getting things up as fast as they possibly can to fix that. So that's that. And you guys can always join us on any of the platforms. We're on Rumble, we're on Odyssey, and we are on YouTube, even though on YouTube, I will end up having to block out the fun little meme scroll that's up in the corner. Can't have that on YouTube. With that, thank you guys for coming. It's good to see all of you.
Thank you, Zen.
Hope you have a wonderful rest of your weekend. And next Saturday, we will do this again. And until that time, stay safe and stay sovereign.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes